Hello, today I want to talk to you about the key case of Salomon and Salomon, citation 1897 square brackets appeal cases at page 22. Most people use this authority, of course, as a company law authority to demonstrate that a company is a separate legal juristic person with rights and responsibilities of its own, and that its shareholders are limited in their exposure either to the amount of value of the shares that they have in the company, or if they've guaranteed exposure to the amount that they've guaranteed, if it's a company limited by guarantee as opposed to a company limited by share. It's of course in the company's constitution that we'd find those ingredients. So Salomon, a case that Grantham and Ricketts has said has a reverence bordering on religious, and those that are praying to the Salomon deity, of course, are company law scholars. But today I want to argue in this video that Salomon can be taken just as much as an insolvency authority, a corporate insolvency authority, as much as it can be taken as a company law authority. And of course, for that other reason in company law as the separate corporate personality point. Why is it such an important case for insolvency, you might ask? Well, it's for a number of reasons that we might consider Salomon through the prism of insolvency. The first is because of the idea of a battle for value. The case, and you can take other instances of, for example, on this point, had as the key proponents or key players in the litigation various office holders. Of course, on the one hand you had the liquidator who was acting for the unsecured creditors, and on the other hand you had a receiver, somebody who was acting for, in the first instance, Aaron Salomon, but then subsequently, of course, Edmund Broderick. That's why at first instance we see the 1895 decision, unreported decision known listed as Broderick and Salomon, 1895, the decision before, or the case, and the subsequent decision that emanated from Mr. Justice Vaughan Williams, as he then was, Roland Vaughan Williams. So the first reason is that we have various office holders who are arguing, debating with each other. So the liquidator for the unsecureds versus, of course, the receiver for the secured creditors, Aaron Salomon, and then, of course, Edmund Broderick, as I've said. That's the first reason. The second reason that we might think about it is, of course, that the judge, as I've just said, at first instance was Roland Vaughan Williams. So Roland Vaughan Williams, later he became, of course, Lord Justice Vaughan Williams. He was a vastly experienced insolvency judge, amongst other subjects. He was the first author of Williams on Bankruptcy, which went through 19 editions before it became a loose leaf in 1986. It still continues to be published, now known, of course, as Muir-Hunter on Personal Insolvency. And it's important for us to think about Vaughan Williams and the way in which he acted at first instance. We know that he talked to the idea of principal and agency, with Aaron Salomon being the principal who would indemnify the agent company, and in that way we saw that Vaughan Williams thought that there was some duplicity, some activity that Salomon had been up to which was capable of rendering the separate corporate personality of that juristic person void, so that Salomon, as its principal indemnifying principal, would step in and take up the burden of the company's exposure. And we know that subsequently that the legislature in the Companies Act 1906 and then subsequently in the Companies Acts of the 1920s specifically promulgated provisions that meant that any debentures that were created in the early days of a company, much like Salomon when he created Aaron Salomon and Co Limited as the juristic person here, he's here as a participant who of course participates as a shareholder, but also has this super priority, doesn't he, as a separate debenture holding secured creditor. And Vaughan Williams was suspicious and said, of course, that this kind of activity gave these incorporators a super priority over the unsecured creditors. He was used to seeing this, of course, in many cases that came before him and the cases that he wrote about for Williams on bankruptcy, perhaps, and other outputs. So when the legislature come along with their Companies Acts in due course and ensure that if any debenture, in the first instance in 1908, that is issued by a company within 6 months, is automatically set aside. This, of course, alleviates the kind of super priority that Salomon was able to get from causing the company to issue him with that debenture. As I've said, in the Companies Act of 1928, we then get a extension of that 6-month period to, of course, a year, so that if any juristic person causes a debenture to be issued within a year, it will be viewed that that can be set aside as being problematic because it gives that super priority to its incorporator that harms, of course, the unsecured creditors. So that's the second reason we might look at the case through the insolvency lens or prism. That's to say, because of the vastly experienced input of Lord Justice Vaughan Williams as he became. As you know, he, of course, Roland Vaughan Williams, is the uncle of Ralph Vaughan Williams, the famous composer who, amongst other things, composed the song Lark Ascending. The next and third reason we might consider Salomon and Salomon through the prism of insolvency is because of the discussion in the House of Lords. So it leaves Vaughan Williams at first instance, goes up before Lopes, etc. in the Court of Appeal, then goes up to Macnaghten and his brethren in the House of Lords, where we know about the various discussion points around limited liability, and of course the ultimate acceptance by the law lords, as they then were, of the legislature's provisions in the 1862 Companies Act. We know all about that, but from the insolvency perspective, what would we look at? What can we take and extract from those judgments? Well, I'll just focus on Macnaghten, so Lord Macnaghten. And you'll remember that in the case, he says, or critiques the position of security, and says that he has, quote, some sympathy for the unsecured creditors, close quote. But he goes on to speak about the idea that, of course, those unsecured creditors are able, if possible, to protect themselves, much like Salomon does with his debenture. So the interplay between secured creditor interests and unsecured creditor interests, going back to our first point of consideration, liquidators versus receivers, we might consider, by looking at Lord Macnaghten's judgment, that these competing interests are helpful and useful, but as Macnaghten says, ultimately security must win out because, of course, it's encouraging for creditors to be able to get security and protect themselves. Salomon isn't the only judgment, of course, we could look at through this prism of insolvency. High Trees also, you'll remember it for Lord Denning's judgment on estoppel from your contract days. Of course, it does talk to estoppel, obviously, that's what it's known for, but if you drill into the facts of the case, you'll see that in fact there was a battle for value underway, not between a liquidator and a receiver like in Salomon, but in, of course, High Trees, it was a receiver looking around to see how they could look to value within that company that owned, of course, that famous block of flats that's become immortalised through Denning's judgment. And then also Mull, of course, on the judgment of Lord Macnaghten and what he says about the sympathy that he has for unsecured creditors, but equally how he recognises that secured creditors must win out and that the extension of protection to them is very valuable for commercial relations. As valuable, of course, as the judgment ultimately is in Salomon and Salomon. And when I say judgment, I mean the elements of it that relate to limited liability and the extension of that statutory privilege to those that wish to undertake business other than as sole traders or as partners in partnerships with their joint and several liability if they're not operating with an LLP. So think about Salomon, mull on that, and as you do, I'll leave you with a little snippet of Roland Vaughan Williams' nephew's composition. That's of course Lark Ascending, which you can relax to now after this insolvency short. Enjoy.